Good morning, good afternoon, everybody. My name is Tom Byron, for those of you who don't know me. I'm a PhD student in French literature at Boston University, but I'm also in-house counsel at a software company called the MathWorks, which for those of you who are into technical computing software would know from MATLAB and Simulink are the most popular products that we make. So this paper, which tries to plumb copyrightable creativity both from a deconstructive and then a reconstructive perspective, tries to marry those two interests, both the French literature, French philosophy, and my love of copyright law. So we'll see how it goes. So when starting with creativity, I was tempted to try to appropriate some type of creative language, and I was struggling with sort of a starting point when gift wrapped on the newsstand came the Rutgers researchers who recently wrote a program that determines creativity in art. So they wrote a program that will take in whatever their image processing allows, and then they will process it, and based on a certain algorithm which measures both originality and novelty measured historically, they can determine, allegedly, what is creative. So they did this with 62,000 pieces of art spanning the Renaissance to modern times, and they found, I think things that we would sort of expect. Leonardo da Vinci was really creative, Piet Mondrian was very creative, and meanwhile other people were not as creative. And that struck me as something that for those of us who care about creativity in the copyright sphere, obviously we do in a lot of different ways. This could be really helpful because we consider creativity in joint authorship. People have discussed how creativity, Professor Mandel has discussed that, how creativity plays in there and ideas of creativity. Another example would be derivative works, the Batman case, the piggy bank. And then obviously the example I want to use here is Feist, the 1991 case that required a modicum of creativity for an author to merit copyright protection. So this seems like it could be helpful, but, and this is where I start thinking deconstructively, and start to wonder, is this too mechanistic? Is there any value to this? What are the limits to something like this? And the limits that the researchers who wrote this program will acknowledge is it's based on whatever they plug into their database. It's based on however they set their algorithm with how they come out with creativity. And that started for me to shadow how courts think about this, and maybe there's a little bit of a comparison between the way this program operates and the way courts view creativity copyrightably. So with that background in mind, I want to think a little more broadly about creativity, and I'd like to discuss it from three perspectives. First, the easiest way to define creativity when we think of it as an adjudicative matter is just to go to the courts themselves, because for whatever we think creativity is in the ether, in reality, courts have proposed certain methodological practices to determine creativity. Then I propose to take a second step and look at some criticisms of how courts envision creativity. And then my third step, and this is where I try to bring to bear a little bit of philosophy, is importing the philosophy of Henri Bergson, who's from the early 20th century, to this creativity analysis to try to help us maybe work for something that's a little more positive. So the idea of this would be sort of a sine wave, that we start from nothing, we build with courts up, tear them down with a bunch of critiques, which I think will fit well with what you're discussing, and then try to rebuild again. And I think that's a nice little image for creativity, because creativity does sort of come in waves. All right, so to start with the judicial background. Obviously, everybody knows the Feist case requires a modicum of creativity for a work to merit copyright protection. But what it didn't do beyond that was much else. So it gave you a yardstick, but it didn't give you any of the inches on the yardstick whereby to measure creativity. And it was kind of a lousy case in front of it to begin with to try to do so, because you get to use words like trivial and garden variety as they do in the decision, but that doesn't really get you anywhere. And it certainly doesn't give you any kind of notion of the positive, what is creative, if we can say what isn't creative. There's always going to be a space, logically, between those two sets. And yes, and as you said in your article, there's no workable standard that came out of that case, and I think that's the right way to look at it. So what that left is a lot of space for courts to imagine creativity after their own fashion, following Vice. And I think the approaches courts take can be broken largely down into sort of two approaches, each of which turns on how they relate with the idea-expression dichotomy. So I think there are some courts that view creativity as sort of coextensive with the idea-expression dichotomy, and then there are courts that look at this as a separate inquiry that requires, maybe a different methodological approach. So with that in mind, I don't know how much I want to go into idea-expression dichotomy here, because I think everybody here probably knows more or less what we're talking about. But I. Well, all right.
Maybe the people on this side of the room.
Okay. So in brief, obviously, the idea-expression dichotomy is the textbook definition that ideas are not copyrightable, but that expression is copyrightable, and that there is somewhere, and basically there's a famous learned hand quote that on any work, any number of levels of generality can be built, abstracting away from the actual expression on the page. And at some point in those series of abstractions, copyright sunsets and the unprotectable idea arises. The problem with this, of course, is that there's no way to know what that line is between idea and expression, and learned hand acknowledged as much in the case where he was discussing it. So what courts, so again, another space where there's a certain mobility. But the way courts generally deal with it is they do tend to pick high levels of idea, and the question then becomes, can we find alternatives for ways to express that idea, which is a sort of Lockean property analysis. If you have enough and as good ways of articulating a certain idea, you can merit copyright protection. And then the flip side case is obviously merger, where a court defines an idea such that the expression is basically follows as a necessity from that idea. And there are only a few alternatives whereby to measure protectable expression. So obviously the issues already discussed. This is a mobile thing. But the second thing I always like to focus on as well is, as you move the boundary between idea and expression, it doesn't just set a boundary, it also sets the way we think of alternatives on both sides of the boundary. So the higher you go with the idea, the more alternatives can bleed into that area of expression. So it almost has a sort of two-body problem dynamic to it. So that's the idea-expression dichotomy as sort of a backdrop. Now, as I mentioned before, there are courts that seem to view idea-expression dichotomy as coextensive to creativity. And the American Dental ADA Delta Dental case was mentioned in this respect, and I think that case is just dead on in terms of that was the dental taxonomy case, where the court basically said, as long as you can find alternatives for doing something, it is creative. And they used the word creative in an analysis that looked like an idea-expression analysis, but the word creative is actually in the court's quotation. So it bleeds the two together. And I think there are a number of other cases. The people are very critical of the Google versus Oracle decision that recently happened, but that decision noted, alternatives available to Oracle, alternatives available to Google when they were programming. So you have this one side where there seems to be an alternatives-based analysis driving creativity. The question is, how do other courts approach it, and how can we treat it as a separate inquiry? Some courts play up a little more authorial choice, between the alternatives, and maybe that's a little bit of a distinction. And I think that's a fairly common one. The authors choose among a number of alternatives for expressing an idea. Other courts seem to maybe put a little bit of a probabilistic shading on it. There was a Matthew Bender case in the late 90s which used the word non-obvious, which is probably kind of problematic because it's a patent word. But that non-obvious thing suggests there are less probable things and more probable things, and we want to favor the less probable things. But again, I think these are very minor tweaks. I think that's just a minor tweak on the sens faire doctrine in that case. So what I actually liked was Judge Alito's opinion in South Covey, Cambridge, where he found a parts number taxonomy to be uncopyrightable. And when distinguishing it from photographs, he noted that photographs have complex and indeterminate ideas. And I actually like that because I think that moves us way away from being a duplicative idea expression inquiry when we're dealing with creativity to something that's different. And now what is that complex and indeterminate thing remains to be seen. So we've got a few criticisms. Now we'll switch to the second part. I already have a few criticisms of the idea expression dichotomy and using alternatives and choice among alternatives as a means of creativity. And I don't think that's the right approach to the extent courts adopt it. But there are plenty of other ways to look at why I think that's wrong. One example, and I'm glad to be speaking here at DePaul because Professor Paul, I didn't met you. Hi. Professor Paul's written a lot of stuff on creativity and how it, and done some nice readings of Genesis and the creation narratives in Genesis, and how it's a very process-driven, and it's a process. Creativity is a process-driven phenomenon, and it's a processes and breaks and activities and inactivities, lulls and or ebbs and flows, if you will. And that doesn't really fit into this idea expression thing. Engaging with the cultural landscape is another example of where this fails, because it doesn't think about the author. This is something that very much prizes that romantic author ideal, this idea expression, alternatives notion, where really, and this is something that lots of people have written on, Madison, Julie Cohen, that it's the author's engagement with the cultural landscape around him or her that matters and that creates creativity. It's not somebody sitting alone in a room who has an idea, then imagines a lot of alternatives and chooses one of them. That seems like a very wooden and kind of silly way of looking at it. And then it sort of plays on other dichotomies, like a left versus a right brain dichotomy, which goes to the rationalism point. And it also plays on the natural rights versus economics dichotomy and forces that on us rather than allowing sort of an expansion into cultural space. The title of my paper is À la recherche du sens perdu, is a play on Proust's, obviously on Proust's novel À la recherche du temps perdu, and I use as an example for where this alternatives method fails. The very beginning of Proust's novel, the first sentence he wrote, it was longtemps je me suis couché de bonne heure, and that sentence is, I think, wildly creative. Yet at the same time, there are basically no alternatives for what he did. You could never write it using, maybe one or two words could be changed. And under an alternatives test, obviously this is not creative. Yet this idea, longtemps je me suis couché de bonne heure, for the longest time I went to bed early, is actually wildly creative because of the verb tense he chose. He chose to use the passé composé rather than the imparfait. I don't have a lot of time left, so I don't want to get into French language too much. But it's a really creative choice of verb tense that nobody would do, because it doesn't make any sense. It screws with the time scale of the first sentence, where something that should have been happening durationally was happening in a single snapshot. So it totally throws off the time perspective, and that's something Roland Barthes talks about when he talks about this sentence. So you have, and there are a million other examples of things like this, where in order to express the idea there and to do it the way a poet or Proust did, there just are no other ways of doing it. And are we going to deny copyright to those people because we have a bad methodology for choosing creativity? And my final criticism of that before I jump to Bergson is it's totally unrealistic. I don't think anyone's ever asked somebody else, did you think that film was creative? And the other person answers yes. They really chose one of many alternatives. It's foolish. No one would ever say that. They say things like, that was unpredictable. That made me think. I thought it was creative because it was cool. Whatever. So I'll flip it out of Bergson. After I think doing an okay job deconstructing this alternatives-based analysis for copyrightable creativity. Just to give a quick sentence on Bergson, he won the Nobel Prize for Literature in the 1920s, and he had a career that spanned from the late 19th century into the 30s, more or less, 30s, 40s. And he was a notable philosopher, obviously. for those of you, I'll assume less background on this, and note, you can sort of collapse Bergson. Bergson challenges people to collapse philosophers' views to a single point. And I think we can collapse Bergson reasonably to something like, he teaches sort of the dynamic unfolding of a continuous process, and over a continuous period of time. And that starts to speak to some of his criticisms of human reasoning. For Bergson, human action is driven by the ability, more or less, to survive. And that means that humans constantly have to abstract things and imagine them as repeatable so that you can choose how you want to react to a later situation that presents a similar fact pattern. So that implies that we think of things as being repeatable. We think of things as being reversible in a lot of cases. And in another one of his criticisms, we like to break things down into snapshots. So if you think of the flight of an arrow from point A to point B, Bergson talks about how humans tend to break it down into, it hits the midpoint, and it hits the quarter point, and whatever. But doesn't tend to think of the whole movement, the whole process. And what he calls it the méthode cinématographique, the cinematographic method of looking at things. So those are just sort of some, we're running a little short on time. Those are some basics of Bergson. And then add in, so he basically faults humans for reducing things to things and states, and adolescence, adulthood, end of life. So that's one criticism, and as an outcropping of this, Bergson was asked once after World War I, where do you think literature is going to go following World War I by some interviewer, and he was taken aback by it because he was being asked what's possible about literature in the future. And for Bergson, there are two types of possible. There's the possible where there's no obstacle for something to happen. And he's fine with that, and he doesn't really care about that, because that could be anything. But what he cares about with this prediction, and why he punted on the question and said, I could never say what this is, what is possible for literature. All I can say is future literature will have been, eventually, in the sense that the possible only becomes possible when it becomes real, when it actually it takes on a physical form. And that's something where I think we begin to get a nub from all of these little Bergsonian criticisms that the alternatives-based methodology fits in all of these failures of human reason that Bergson notes. It tends to reduce things to snapshots. It tends to it tends to presuppose this idea of a possible that happens before the real, in the sense of an idea. And then it presupposes a lot of possibles that never come into being. All of these different alternatives that someone could have chosen from, which don't exist, and never have existed, and maybe never will exist, and in his sense are not actually possible. And again, it creates sort of a Cartesian plane of different ideas where they're all possible. So the question is, what does Bergson do to break this up? Sorry, I'm rushing. I think there's a better way to present his criticisms, which I think are just dead on for using abstractions-based, alternatives-based method for creativity. So he focuses on that continuity. When you think of the flight of the arrow and the example I gave, where humans tend to break it down into snapshots, Bergson's idea is to think about things as processes, and think about them as undivided, think about them as movement. And with creativity, when we think of, even in the courts, we should be thinking more about things as a continuous process. Creativity, the work is never done. We break it down into these tangible fixed points, but we need to think about the process that led up to that fixed point in the particular artifact that we're trying to find creative. And the example he gives eventually, as a possible, this is all about, this ends up being a little bit indeterminate, because Bergson was a philosopher of the indeterminate. But I think even in his indeterminacy, where he finds indeterminacy around us at all times, constantly renewing, never repeating, I think even in that we could probably say something like the phone book in Feist is determinate, because it is effectively determinate. But how else would somebody have done that? That particular artifact. But I think outside of that, there's a wide range of indeterminacy where creativity lives. And he gives a little example with the Mona Lisa. And I'll skip that. Let's just. So to the focus, and just a closing point. So yeah, so it's a little hard to find where I think Bergson would take a creativity analysis to make it very structural, but I actually don't necessarily think that's a bad thing. I think there has to be a certain degree of play and determinacy in this, where if we're trying to capture people who behave a little more like the romantic author and people who behave a little bit less like the romantic author, if we're trying to capture people who like to create like George Perec and they don't want to use the letter E in a book, if you want to capture people who are a little more rigid, a little less rigid, people who just do it like surrealists and just write it on the page and just see what comes out. I think we have to have a certain level of indeterminacy and creativity, and I think the way we do it right now through the Feist, the way courts have interpreted Feist using alternatives is really not the right way to do it. So that's it. I'll stop here in a minute.
I may not have completely followed your argument, but I think Chris's diagram here is actually really useful to you now.
Yep.
Because you're talking about creativity and indeterminacy and what's sort of obvious or unobvious, sorry about the patent language, choices.
Yeah.
But that's not the same as what's a copyrightable choice for creativity purposes. And so I think you need to maybe slice orthogonally what you're doing and think about it. Yeah, I need to know what creativity is, but then, at least according to the title of your paper, my real purpose here is to eventually get to what part of that creativity is relevant for copyright, because I'm not sure you made that distinction, at least I didn't hear it.
Okay.
So I'm from Louisiana, and I appreciate speaking French. Baton Rouge sounds much better than Red Stick.
That's right, that's right.
You need to be a little careful of that if the audience doesn't speak French. Just a bit of advice. In terms of your critique of the idea expression dichotomy and the numbers of ways in which you can express it, you said that a number of times.
Yeah.
What you don't seem to realize is that defining the it is the whole game.
Oh,
It's
yeah.
only once you define the it you can determine if there are many or few ways to express it. So when you talked about the first sentence, for a long while I went to bed early, as if that were the it, that may not be the it at all. Right? The it may be
No, the it
a
is-
surprising and startling new sentence, the first sentence that captures the reader's attention, in which case there's lots of ways to express it. So I think you may want to think about that a little more carefully.